terms of reputation management, we've seen a lot of new rules and regulations coming out about when athletes can tweet and what they can tweet about. And how, as a lawyer, how do you advise and talk to your clients about brand management and really identifying themselves in the right way to avoid some of these issues?
That is. Can you hear me okay back there? That's a very timely topic because I think most celebrities, when I say celebrities, I mean athletes in that definition as well, are starting to recognize that they truly are a brand, that their personality, their name, their image really, truly is definable as a brand. And as such, whatever they say and do in the public eye can affect that brand either positively or negatively. So this communication medium that we have now that gives people the opportunity to push up a button to send a message that hundreds of millions of people can receive and see and can interpret and construe in whatever way they wish can really affect how someone is perceived in the public eye and affect that brand. And in some cases, the damage may be irreparable. So what you have to do is always counsel people that think before you push the button. Think about the ramifications of what you're saying and the effect it can have on your career as an athlete if you're presently playing in this particular sport, or the effect it may have on business opportunities and ventures that you may be engaged in or planning to be engaged in after or during your career. So that's a pretty basic way of defining it, but it really does require a lot of hands-on control and management because oftentimes people get into a situation that they really don't have control over and they don't realize the mic is running or the camera is on and something they say ends up on TMV and now it goes viral and everybody's seeing it and watching it and they have no control, they can't pull it back. So oftentimes you just have to say, choose your company well, choose not to go into certain situations where you don't have control over what's going on around you and who is watching you and listening to what you say, and just try to keep your circle as tight-knit as possible.
And we're seeing it too recently with Lindsay Lohan. Judge Stephanie Sotner specifically said, you should really stop tweeting at the morgue. Like, it's a little ridiculous. So it's an interesting predicament when you've got celebrities and athletes kind of really wanting to reach out to their fan club and kind of overstepping that line.
Can I say something about that? I also do a lot of work in the music industry, and what I've been reading for years and what they're saying, the intelligentsia cognoscenti who are involved in promoting and representing and advising, is that the new deal is to be in touch with your fans. And the reason Taylor Swift is so big is because she used MySpace better than any other performer probably in the last few years, and had 3 million followers, etc. And every person who likes her music feels a rapport with her. And that's what is happening right now that I'm seeing. What they're telling everybody is this direct relationship is going to happen. Because it's also happening at the same time is, in many ways, the diminishment of the end of the traditional channels of distribution. Anybody can put out their own music right now these days. So you've got to figure out a way to promote it. And as he's saying, you better not say something stupid when you're doing it. And that's what's happening.
And in that same kind of vein, one of the cases that was mentioned in the introduction to this is the Lindsay Lohan suing Pitbull for using her name in the song Give Me Everything. I guess the lyric is, I got locked up like Lindsay Lohan, and she's saying that's defamatory. Anyone you kind of want to touch on that a little bit and where that case might be going?
Well, I chuckled when I saw that because, I think in many ways she's delusional in thinking that somehow her name being used in a lyric somehow enhances the consumer value of the recording. And then secondly, I mean, it's a song, and I think there's a viable argument that it's commercial speech. It's a speech that should be protected, not the way commercial speech is protected. And he's actually stated a fact, which is he was locked up like her. So I think that there's so many obstacles for her to overcome that I would have, really thought twice about bringing that kind of a lawsuit, given all the other issues she has going on in life.
I would say, it sounds to me certainly it's commercial speech, and there was the Barbie doll case about 3 years ago where the same thing happened, and with Universal and I believe Mattel were in litigation, and Mattel got blown out of the water. But there was a case, and I don't know, I can't remember exactly, but Rosa Parks, remember about a case about 5 years ago on a rapper, saying that she was demeaned in some song, and she got past, the pleading stages in that particular case. So it's certainly, I mean, I'm not going to say defamatory stuff can't happen. Defamatory speech, you can be defamed in a song, let's put it that way. Whether Lindsay was highly likely.
And we shouldn't forget one of the principal defenses against defamation, and that's the truth. And if she was locked up, and there's something about that fits into the song, she's going to have trouble overcoming that defense about it being true.
Well, kind of another one of the cases that was mentioned in the introduction, the Kim Kardashian case, where she sued Old Navy for using a look-like model, supposedly, so that they could kind of capitalize on her image. Do you guys want to weigh in on what maybe that case looks like, what her claims are, what their defenses would be, and specifically what with the model, is she going to have any issues going forward with her career, since she does look kind of like Kim Kardashian?
I have an opinion that if you've read the Vanna White case, and most law students will read it, it's one of the one case I despise the most, and I'm no longer a fan of Vanna White because of it. She won a case for misappropriation of her image and likeness on this Wheel of Fortune parody about the future. And what I got from that case about the case about Kim Kardashian is if the defense frames the issues properly, they're going to direct the defense toward, this is not about Kim Kardashian, it's about people who are like this, who go shopping this way. I mean, go to the mall in Scottsdale, look at the way that people are dressed when they go shopping. Okay, there's something to be parodied about that. I make fun of it all the time. I'm sure some of you do, especially if you live on the west side of Phoenix. You like making fun of people in Scottsdale. So, and I think that's what that Old Navy ad was doing. So if the defense focuses on what they were really talking about in that ad and what they were trying to make fun of or parody, if that's in fact what they were doing, they'll have a better outcome than defense in that Vanna White case.
Well, I think there are some threshold issues that have to be overcome. One, I think I would expect the defense to argue that any resemblance to Kim was purely incidental, because it turns out that that ad was part of a series of ads, and in none of the other ads was there anyone shown who looked like a celebrity. And in this case, they would probably argue there was no intent to use someone who looked like her. She just happened to look like her. And if you look at all of the other ads, we didn't try to place anyone else in any of those ads that looked like any particular celebrity. And I think arguing that there was no knowing use is going to be something that they will make. Now, Kim has a case in that she is recognizable. She is recognizable as Jackie Onassis, who was able to get an injunction against Christian New York back in the 80s for using a lookalike in a print ad. No, but and the Gap may probably argue that the number of people who would recognize her in that ad pretty minuscule in comparison to the larger population to whom they were marketing that advertisement and marketing their product. So I think there's so many issues on both sides that have to be balanced. But I don't think this is the kind of case that would get thrown out of the pleading statement that she has a culpable claim. The question is whether she can meet those threshold requirements.
You know, this isn't parody in the context of copyright where there's a whole test that you apply as to whether or not they exploited to an unfair extent the value of the copyright, as it may be. The last case of this was Woody Allen was sued by American Apparel about 2 years ago, and he capitulated the day before. I mean, the American Apparel capitulated for several $1 million right before trial. I haven't seen the ad, but if it looks like Kim Kardashian, and they're trying to give you the impression it's Kim Kardashian, I'd say the Gap's got some serious problems there, potentially, because this is commercial speech they're out to make a buck on this, and they're out to trade off of her star power. On the other hand, I mean, there's certainly room in our culture and in the advertising world for parodies of celebrities who are obnoxious.
See, I think that's the real question is it a parody of Kim Kardashian as opposed to someone who happens to look like her that's in the advertisement? I think that's really the issue. It's a fact question that's going to have to be resolved.
And I think, how does it come into play that she can show actual confusion? Exactly the first airing of the Old Navy ad, her Twitter blew up with, why is Kim Kardashian suddenly promoting Old Navy when this happened? I thought she was launching her own clothing line this year.
Well, there you go. That shows the confusion.
How will that come into play?
They'll present it in court, and they'll also do, you know, in cases like this, you would go out and do a study. It probably cost $50,000, but, you know, the Gap is not exactly a fly-by-night operation.
Well, they are closing 200 new stores, I think.
No, my question is based on this. Would Sears have standing in that case if it's found at the pleading stage that there would it be an interference of contract or tortious interference? Because her direct deals are with Sears and hers on Navy.
I don't know about, she said, the question is, would it be an interference with contract? Or, I don't know, I haven't ever seen that pled. I mean, I actually got the complaint here. It's for unfair competition under the Lanham Act, violation of the California of common law, right of publicity, and the California Civil Code, which I should just mention in the deal. We sometimes plead one and not the other. We plead the common law. We don't plead the Civil Code because if you lose in the Civil Code, you got to pay the attorney's fees on the other side. So if we're at all worried about if there was any possibility we lose, then we tell the client, hey, let's not go that route. But she's going trademark infringement. It's the equivalent of trademark or right of publicity.
One of the other cases that was mentioned in the introductory materials was the Mike Tyson tattoo case with Warner Brothers, and that's one of many cases that we hear about that settle out of court before litigation gets going. All these kind of things that want to be kept secret get revealed. Can any of you kind of comment on how those negotiations tend to play out and how those deals kind of ultimately form?
I'll start. I like that case. To me, it was easy to discreetly look at what was going on in that case. And it actually doesn't fall under anything of defamation or privacy. It's not about that at all. It's about strictly copyright infringement. And so I guess the lesson to learn from that as students or lawyers who want to get into this field is it's important to know what your causes of action are and make sure you get them correct. And what actually happened here, Mike Tyson isn't involved in this at all, is the tattoo artist owns the copyright in that design. And the tattoo artist sought to stop that film. And I think it's Warner Brothers didn't want that to happen. Of course they did, because they have a great franchise going with that whole Hangover series. So they settled with the tattoo artist to avoid a claim to stop the film, because the court probably was going to enjoin those scenes, and they would have had to re-edit the film, and it would have been a nightmare for Warner Brothers, so they paid him to go away.
I'll give you a variation on the theme, which is we had a client a couple of years ago who has tattoos, and they went in for a cattle call and got paid a few $100 or whatever, and they took pictures of him. And the next thing you know is that without his face, his body was the model on a worldwide international campaign. And we went after the ad agency and the company saying, he didn't sign up for this. And he did just fine. Now, and I grant you, he didn't own the copyright in that as well, but it was his image we were going for there because they were actually using his image. So I'm just saying, if you're on the side of representing ad agencies and studios and all these people, be really careful about what you are allowing to occur. I'll give you another example. A client of mine goes to Coachella some years ago. He's a 14-year-old boy. Somebody takes a photograph of him and then it's later digitized basically, and he becomes the image of Ticketmaster for the entire summer. And everybody's going, hey man, how'd you become a model? What's going on? What are you talking about? He was just standing in a crowd. And so that was, and they're going to allege, the defense in right of publicity is transformative. Did they change the image enough so it's art, so to speak? And that's where you got to tell them, yeah, I think you need a little more color there or something.
The interesting thing about the tattoo case is I don't think anyone can name who the artist is, but you identify it as, Mike Tyson's, tattoo. So he was very fortuitous in that he happened to put his art on the face of a very famous person who got more publicity for that art, and therefore enhanced the value that he could extract from the studio to be able to,